While most of my clients understand the importance of having a will, what actually makes that will valid in BC? For a will to be valid, it must meet certain requirements as set out in the Wills, Estates, and Succession Act of our province. First, it must be in writing. Secondly, it must be signed by the will maker at the end of the document. Third, the will maker's signature must be properly witnessed by at least 2 witnesses. Those witnesses must actually be present at the same time and also present at the time the will maker signs. A will maker must be at least 16 years of age, and the witnesses must be at least 19 years old. What happens in the event a will doesn't meet all the requirements as set out in the legislation? That will might be cured by way of a court order, and that simply means that the court can uphold the entire will or possibly only portions of it. I have to stress that curing of a will is more of an exception than the rule. This is why it's so important that if a client is considering preparing a will, that they speak to a lawyer about doing it on their behalf. This not only gives the client peace of mind that the will meet all the formalities as set out in the legislation, but also that there's less likelihood that the will be challenged down the road.